back to the show. This is The Law Show on CL 650.
She got the gold mine. I got the shaft. They split it right down the middle, and then they give her the better half. Well, it all sounds sort of funny.
All right, we can just let that play.
She got the gold mine.
All right, this is The Law Show, and we're talking about family law and dividing assets and everything that comes along with it. David Halkett is in studio with me today, partner at McQuarrie Hunter, along with Sarah Morse, associate at McQuarrie Hunter in Surrey. Now, we did touch on a sort of like a pretty dark, heavy subject when it comes to abuse in a relationship. So a lot of times people don't want to tell you, but it eventually comes out. But you might get some people that come to you right away and just say, this, I don't want this anymore. Something's happening. What can you do? And as you mentioned before the break, when you go to a lawyer, sometimes the abuse ticks up, right?
Yeah.
So what do you say to your clients, and what can you do for them?
Well, there's a couple of things. First is, if there's ongoing violence and my client is concerned that it's going to continue, I always tell them, look, the quickest way sometimes is a 911 call, and the police will come, right, when it's that. The benefit to the complaint to the police is that, of course, there's no legal fees involved. It's all taken care of through the Crown.
And there's a record then of
exactly
them coming.
Exactly. They can also at times go down and do what they call a without notice order, and I do those in only extreme cases for the concern that when the other party is served, there's a great chance of violence. And
so without notice means you're not notifying them.
Then you're going for an order.
Right,
exactly. Right. And you go down and you say no contact order between you and spouse and you and the children, etc. I've said this before, but it was just recent at another dinner meeting I was at where it was a famous judge in Surrey, the Surrey courthouse. And as he said, that the downside of protection orders is that papers never stopped a bullet or stop knife from stabbing.
Well, that's what I was going to ask you. How successful are these orders? I mean, once somebody gets one, do they go, oh, geez, I better stay away? Or do they? I mean, what was
the irony is that the order will only stop someone who was probably not going to do anything in the first place. Mm-hmm. And for some people, they get in such a rage at a separation, and if they hit it with this, they don't care. It's almost like they've gone like completely rogue, and they'll do whatever they wish. So it's a tough one. What I often will tell my clients in that is, if you're going to be doing this, make sure you have a plan where you're going to stay until the person's served. And sometimes there'll be what they call a sunset clause. It means that it runs out in 7 days, but you have to go back to court again in 7 days. At least give the other person a chance to give his or her side of the story.
So, Sarah, is that always the best plan, is to have them, I'm guessing often the woman, to stay somewhere safe, that maybe the ex or soon-to-be ex-husband might not know where they are?
Yeah, if there is a fear of violence, absolutely. When I did my violence screening training as part of my mediation training, as David mentioned before, that is the biggest predictor of violence. Like, it's a trigger that the actual separation itself. And if someone's going to do something, that's when it's going to happen. So, yeah, absolutely. If you are able to find a safe place to stay, whether it be a transition house, we have some fantastic ones on the Lower Mainland, whether it's a friend, a family member, if you can drive a different vehicle, there's things you can do to help protect you, because like David said, the orders, sometimes aren't worth the paper they're written on. I mean, they're at least there, so you can go back to them and they're on file. But if someone's going to do something, they're not going to necessarily care that there's a piece of paper out there that says not to do it.
Now, can you give me a percentage of clients who have had this protection order and then this person is still being violent with them after the fact? Is it quite rare? Yeah,
it doesn't happen that much, because I think often someone who's served with something, if it doesn't happen in the first 24 or 48 hours, going to do something, they probably go to a lawyer. Then they calm down. If someone comes and they've been served with something, with me, they're always really choked, obviously, right? They've been served with something, and the downside is it may take them a while to get around to deal with it. You may have to go through a trial. I had one that took 15, 16 months to deal with it. But once they talk to the lawyer, I would tell them, look, the worst thing you can do is do anything that's going to breach the order, because you can get arrested. It's going to look, this right now, it was an order that was made based on whatever evidence the person gave, especially if it was without notice. You have your right to give your side of it and let a judge determine it. If you do anything that breaches the order, it's going to look like you were basically
doing exactly what they said
exactly.
to do.
So it's a tough one. But certainly I haven't had many cases I'm thinking back over the 20 years where there was an order that then there was violence afterwards. So usually the order was made against someone who wasn't going to do it.
And what about having a client who is the one who is the aggressor? You obviously...
Oh, yeah, I've acted for those as well, yeah. And none of mine have ever done anything physically violent. They may have, they say, I just happened to drive by where they were. I just happened to be in the same parking lot, which clearly they're still stalking or doing whatever. But, at least that's what was alleged. But I've never had when I've acted for the person who is subject to the order, ever do anything violent afterwards that's ever had them arrested. At least in my experience.
All right. So is this something that's easy to get for your clients?
No, and I mean, I've dealt with protection orders more on the provincial court side, and when I was doing a contract with the government, and unless there was imminent danger, it was very difficult to get a protection order. It literally had to be, this person is going to show up at my door with a knife.
Yeah, they're not easy to get on a without notice basis, because judges realize just what we've talked about so far today's act, that it can make it worse. Mm-hmm. And it seems unjust to make an order telling someone they can't have contact with someone based on solely on one side's evidence.
Well, could be part of the spitefulness that comes out of these things, and then because of that, also it's eliminating contact to children as well, right?
Yeah, and then the tough side of when you're acting for the person who is, been accused of the violence, is that you still have to represent them. We have to put their side, but then there's also studies that show that if you don't accept what the person who's alleged the abuse has said, and you're cross-examining them on the stand or putting it to them that they weren't abused, you're re-abusing them. So it's a really fine line that we as lawyers have to walk.
And does having if you get somebody that says, I want a protection order, and you get it, does it affect the outcome of the divorce ultimately, or is the law supposed to be blind to that when it comes to division of assets and children?
Assets, it's usually blind to it. It shouldn't make a difference, although some can argue that they should get a greater than equal share because they have been. It's a factor that they consider they can't become economically self-sufficient as a result of having been abused. It plays a part in spousal support. I can't work because my self-esteem was knocked through the loop, so I have no ability to work in the short period. With children, it's a definite factor, and the Act says we have to consider the impact of family violence on the ability for one to be a guardian and to care for the children.
And it's actually articulated in Section 37, the Best Interest Clause. So it's something we always have to consider.
And just so it's clear, though, Zach, this isn't a new thing that we deal with family violence when it comes to children and custody issues. We always did it, but now it's specifically, as Sarah said, articulated in the Act. If there was family violence, it was always an issue when it came to it.
So what has changed?
It's specifically set out as a factor now that the court considers. As lawyers, we always brought it forward, but the law used to be that unless it specifically affected the children, we weren't to consider bad conduct. Now it's specifically a factor the court has to weigh.
So if there's some kind of abuse there, long-standing, it doesn't mean that the other party wasn't a good parent.
Yeah,
they might have been mentally or physically abusive to the adult, but not to the children. Yeah. So how do you walk that line?
Well, you have to determine, did the children witness it? What did they witness? Are they showing any effects of it?
Absolutely.
Anything else, Sarah?
Well, and that's potentially has something to do with the ability or capacity to parent. I mean, if that's how they've treated if the husband has treated the wife that way, I mean, does that have something to do with how they're able to handle stress, or do they have anger management issues that may, if they have 50% of the time with the children and they're stressed after a long day at work, are they going to be able to parent those children in an appropriate manner given how they treated their spouse? I mean, there's going to be an effect there. If they only saw the kids, once a night before they went to bed, and all of a sudden they have the kids 50% of the time and have to get them up for school and deal with tantrums and bedtime and things like that. If they have an anger management problem or other issues which showed up in abusing their spouse, that may just show up when they're now having to deal with parenting their children 50% of the time. So
now,
it is
and it's not as easy if I have my children half the time, so therefore it doesn't matter whether I was violent. You still have to deal with the other parent on a lot of issues, whether the children's education, their health,
holidays, things
exactly.
like that.
You have to deal with them, and if you can't deal with your spouse in a non-abusive way, how can you co-parent?
Okay, what about just saying the spouse was abusive as a lever for the divorce? Does that happen? Because you think that my husband was abusive and he's a lousy father and all this kind of stuff, just so you're trying to get one up on them when it comes to negotiating.
Well, I think that's one thing David and I, we talk about is that when you are first meeting with a client, or even along the way when you're preparing for, say, an application on parenting time, we sit down and tell our clients, be prepared. You are going to be served with an affidavit that is going to paint you as the worst parent who ever lived. It's going to be painful. It's going to be awful. Mm-hmm. But we're still going to go in there and we're going to tell our side of the story. And that happens on so many files. It's mudslinging, and it's not necessarily vindictive. It's one parent wanting to prove that they are a better parent because they want more time with their children. So it's not necessarily coming from a bad place, but it comes out that way.
Abusive is pretty harmful.
It is.
I think the studies show that the percentage of people who use that just make it up
as a bargaining
leverage
chip,
is very, very small. And they're usually someone who was mentally ill in the first place. So it's not that they've consciously made it up. It's part of they're just mentally ill. In my experience, I've never had a case where there hasn't at least been some merit to the allegation of abuse. Mm-hmm. Even if it's something that it was emotional abuse or verbal abuse, which I personally may not have considered if it happened to me to be abusive. It's very subjective, and they did. So they weren't making it up. It was just it may be something that someone else may not consider abusive.
Yeah, and that's the whole thing. Is somebody, you've got a pain tolerance at one level, and someone's got it at another level. So what's abusive to me might not be to somebody else, and vice versa. So who's the judge? Ultimately, is the judge in this?
Well, and there's independent evidence. Whether it's from getting a Section 211 report done, or counselors,
other witnesses,
or other witnesses involved. I mean, because that's part of it is differentiating between, is it just mudslinging, or is there something behind it? And that usually comes out along the way.
And when it comes to verbal and emotional abuse, it's, in my experience, it's rare that a judge will say that you can't co-parent because you called each other names. Mm-hmm.
Well, most divorces, there's a whole lot of name calling.
Exactly. And so usually it has to have been something a lot, we all know when we see it. It's hard to describe, but when something was probably verbally abusive when you've
gone across the line.
Exactly.
Yeah. All right. We'll continue our conversation about family law next, right here on CL 650.
There's more of the show still ahead. This is The Law Show on CL 650.